Crypto Law TV. I am John Deaton, the founder and your host. Okay, what are we doing? We are waiting on a decision that is really causing a lot of frustration out there. Let's just address that issue. I understand why people are frustrated. Why is it taking this so long? Does the length mean anything? There's a lot of people out there speculating, and I wanted to take the opportunity to address this issue. Okay, so let's talk about a few issues. Why is it taking so long? That's one of the issues I keep seeing out there. People are now saying something nefarious is afoot because of the length. People are saying the judge is doing the bidding of the SEC. And then I see people saying that there's some type of plot, this predetermined, things were written a long time ago and they're going to flip the switch and the QFS is going to be released. And this is all part of some major plan. And so let's address it. Frustration. I understand why everyone's frustrated. I get this in my private practice all the time. And let me make something clear to people. Unlike the lawyers that work for Ripple and many of the lawyers that are on Twitter, I'm not a billable attorney kind of guy. Now, and I'm not talking about the Ripple case. Obviously, I'm doing what I'm doing pro bono, but I'm talking about in my actual Deaton law firm, non-securities law, non-XRP practice, the thing that pays the bills and pays the employees. I'm not a billable attorney either. I only get paid if I'm successful with my clients and I front the money and the cost and I go after companies that used asbestos. Well, today I was working on a case that was filed in 2018 by me. There's like 3 of these cases. That's 2018. It's 5 years ago. And so to me, this delay is normal because it's the civil justice system and I've been used to it for the last 20 years. But for many of you out there, this is your first introduction to paying close attention to a civil case, a complex civil case. And so my clients would say to me, John, this is ridiculous. It's taking so long. Why does it take so long? Well, I have one judge and that judge has many cases and she's the only judge that can handle asbestos and she just had back surgery. So guess what? For 3 months, we had no court, no cases, no settlement conference, nothing. And so COVID, court shut down, things take forever. Now, that's just a regular case. This is a securities case and people are asking, is this case taking an exceptionally long time? And a lot of people out there will compare it to library and say, well, library was filed after and it's already reached summary judgment. Well, there's many reasons for that. For first, remember, library didn't contest 2/3 of the Howey test, right? Ripple's contesting everything. Another thing, $200 million, that's not fake. I can assure you the people out there that think that there's some plot and everything's been predetermined, there aren't fake billables going to Ripple. When Brad Garlinghouse says $200 million has been spent, those are people working up the case. In the Ripple case, each side has been given, basically got 10 depositions. That's 20 depositions. There were 16 experts. Just to give you an example, the Hinman deposition was like 418 pages. That's a typical deposition in these cases. Well, there have been 20 of those. There have been 16 experts. When you add up just the deposition pages, you're at like 15,000 pages of just fact witness and expert witness testimony. You're talking about 1 million pages of documents. So you've got to think of the complexity of this case. Has this case been longer than normal? Well, it depends. If you look at other cases, they range between 18 months and 3 years. It's really right in the range of these cases. Some cases, like Telegram, took about 1.5 to 2 years. This case is now over the 2-year mark, but let me give you some deadlines. For example, we already went over 1 million pages. I want to think about the different issues in the case. We've got a regulatory gap that we're talking about. This is a case of first impression. We had a Spaces today with Lewis Cohen. He reviewed all of the cases ever since Howie. There's not a case that talks about secondary sales. You've got 15 amicus briefs coming in. You've got the importance that this case is going to have on U.S. economic policy, global trade and finance. You've got issues like, does it morph into a security? Did it start as a security? You got the token itself. There's just tons of legal issues on the shoulders of one judge who has a magistrate, Judge Nett Byrne, who helped, and a couple people who graduated law school, Ivy League law schools, who go and they become what many people call an intern, but they're basically their clerk, and they clerk for Judge Torres. So Judge Torres, how many cases does Judge Torres have? Well, I checked this morning, and she has over 500 open cases on her docket, over 500. And 44 of those cases are criminal cases. Now, some of you out there are going to say, well, this case is more important than those cases. Why don't you ask those 44 defendants if this case is more important to them? Maybe ask one of those civil litigants who their entire livelihood is on the line, whether they think the XRP and Ripple case is more important than their case, which may put them out of business forever. So understand, over 500 cases, 44 of them, we're talking about people potentially serving life in prison, 20 years, 30 years. Pretty sure they want Judge Torres's attention devoted to their case as well. So maybe let's step back and put it in perspective. Now, timing, the reply briefs, all right, Ripple filed a summary judgment motion, SEC filed a summary judgment motion. So each side filed a summary judgment motion, then each side objects to the other side's summary judgment motion, and then each side gets a reply to the other side's objection to each side's summary judgment motion. See how complex this can get? Now you have summary judgment motion for Brad Garlinghouse and Chris Larson, summary judgment on behalf of the SEC, summary judgment on behalf of Ripple. So each one of those briefs over 50 pages. So you're talking about hundreds and hundreds of pages of just the arguments, okay, that need to be gone through. But the reply briefs were due December 2nd. That's 6 months ago, 6 months and a couple weeks. So it's been 6 months from the reply brief. The Daubert motion, the expert motion, was filed on March 6th. Now, I want you to go back when I talked about the timing, and I told everyone when they were asking me, when did I think her decision would come back? If you were paying attention, you would have remembered hearing I said that from the Daubert motion, I had looked at her previous decisions, and there was a decision where she released summary judgment on the same day as Daubert. And there was a decision that she took 2 months after Daubert. And there was a decision that was 4 months after Daubert. And there was a decision that was 6 months after her Daubert ruling. I laid that all out, and I said, when you add all that together and you just average it out, it would get to you, somewhere in May 6th, just before June, whatever, as an average. But there was a case that she decided where her summary judgment decision came in 6 months after her Daubert decision. So 6 months from her Daubert decision, if it was on March 6th, would be September 6th. So I wanted to dispel this thought that this case is taking exceedingly longer for her decision than every other case that she's ever worked on, and that means something. It means nothing. It means that it's one case out of 500, including 44 cases, and it's a case of great magnitude that she knows is going to be looked at from the very day she gives her decision by hundreds of thousands of people, including appellate courts, which we'll talk about. Now, let's talk about this concept of anything nefarious going on, okay? That's absolute nonsense from my perspective. Some of you are going to disagree with that, and I can't change what you think. But I will tell you the level of research that needs to be done. Lewis Cohen, the guy that I was talking to, you all should follow him, New York crypto lawyer. Great guy if you follow the spaces today. Very bright, knows this case law better than anyone in the industry. And in his research article that we were talking about today, that I made in Exhibit B in the Naomi Brockwell amicus brief I wrote and filed, his brief is 108 article, 180 pages. And I was talking to Lewis and he joked and he said that, he shortened his article up. So just to read his article and to go through all those cases, okay, that are all in play, 180 cases. Now, when he didn't even go into the Ripple argument in his brief of the pre-1934 investment contract, that issue the judge has to wrestle with. So that means you're talking about reviewing 1920s and 1904 state law cases that talked about this and looking at congressional intent of the 1934 Securities Act. I'm just telling you that the amount of information that this one singular judge has to go over is monumental. And as soon as she gives her decision, it's going on appeal, right? She rules in favor of the SEC. Ripple is ready. I said from the beginning, Ripple's summary judgment brief is written for the appellate courts. And so she knows Ripple's appealing. If she rules in favor of the SEC is most likely going to file a notice of appeal. Maybe they file a notice of appeal and try to negotiate with Ripple and not appeal, but it's going up. Something of this magnitude where, let's face it, this case will go to the U.S. Supreme Court, most likely, if it goes up on appeal. Right? Everyone's talked from the beginning, a new Ripple test to supplement or modify the Howey test. So if you're the judge writing this brief, knowing that the top justices of the United States of America and the Second Circuit are all going to be reviewing and deciphering every single word, right, that you wrote, you might take your time. So understand that. So she's got to look at that. Now, a lot of people want to know, how is this decision going to be announced? Is she going to call in Ripple and the SEC and tell them no? Absolutely not. Right? Absolutely not. We're going to get a filing on the public docket, just like we did the Hinman emails, just like we did all those other rulings. Right? The public will learn at the same time. The only thing that I'll have and that the Ripple lawyers will have that some of you don't have is, because I'm in the case and I'm a lawyer admitted in the case, I get an email on this phone, right? I get an email that says, boom, there's been a filing in the New York Ripple case. And then I go right to the email and then I see the ruling. That's it. So maybe a lawyer in working the case like me might get, 5 minutes, 10 minutes advance on some people. Also, you got to understand the Southern District of New York deals with financial markets all the time. These judges, these clerks, they get screening, they get FBI, all of that gets done, background checks, because if they have inside information, right? If you're the clerk and you help the judge with the research and you know that Ripple's going to win, boy, right? If you release that, it could get into insider trading and all that. So it is kept top-notch secret until it is published to the public. Okay, so no one's going to get a heads up beforehand. The next question that I see is, Judge Torres is on the SEC payroll and that she's just going to do their bidding. Did she do their bidding on the Hinman emails? No. And all the people that said, oh, it's an inside job, then why did she rule against the SEC? Are you really going to sit there and say, oh, she just did that to give an appearance that she's fair? Come on, right? Let's join reality. Get out of the metaverse and let's get back into reality, please. It's not. And look how long it took to get it. She's methodical, and she's going to apply the law, and she's going to rule how she sees and views the existing state of the law and apply it. And if that helps Ripple, great. If it hurts Ripple, great, as far as her perspective. Okay, so if she was corrupt and on the SEC's payroll, she would have never released the Hinman emails that they fought so desperately to keep private. All right, now, also think about Judge Netburn saying that the SEC lacks a faithful allegiance to the law and that they're hypocrites. Okay, these aren't judges on anyone's payroll. Look at the expert that got excluded, right? She said to the SEC, you don't get to call that expert for him to speculate, basically bullshit what an XRP holder thought in his mind or her mind, because you've never interviewed one in your life. She excluded that. She's been consistently doing the fair, objective thing from day one. I said at the start of this case, when I saw it was Judge Netburn and Judge Torres, I said, listen, that doesn't mean I'm going to agree with every decision that they write. Doesn't mean I'm going to be happy with their decision, but I believe these are fair judges, and I believe that XRP holders and Ripple got fair judges. There are some judges out there that are what we call government hacks, right? That they just side with the government. They side with the government prosecutors. They side all the time. They side with the SEC. They side with the IRS. They side with the government. There are those that are so predispositioned that way that we call them government hacks. Judge Torres is not in that category. She has ruled against the SEC. She has ruled against the Department of Justice, and she's going to apply the law. Now, so what I realized is that this is your first introduction to so many of you to our civil justice system, a very imperfect system that goes by so I tell my clients all the time, the wheels of civil justice, they go, but they go ever so slowly. All right. And it is very frustrating, but to let your frustration start messing with your judgment is when you're letting it just get to you too much. It's frustrating. Chalk it up. The decision's coming. All right. When it's coming, we'll talk about. Another thing that I see out there is this secret plot. And let me just tell you now, if there was a secret plot, then why am I here? If there was a secret plot, why did 76,000 people get together? The motion to intervene that I filed had never been filed ever in the history of the United States. Let me say that again. A motion to intervene by a wife or a husband, when the SEC filed a case against them, they filed a motion to intervene. It was a couple of those cases, one out of Florida, where the wife said, hey, half of that property's mine. I should be a defendant in the case too. Aside from that scenario, never had individual investors come into court and said, hey, sue me too. Your case is so outrageous, SEC, you practically sued me anyways, and here's a putative class action at the time of 12,600 people that grew to 76,000. We want to be defendants too. Never been done. So for you people out there to say, oh, it's a plot and it's predetermined and this was written somewhere on a chalkboard in some secret meeting, then how do you explain us? Because you can't, because it's real. I've been in the courtroom. It's real. That $200 million that Ripple's spending is real. Okay. Just like when iTrust froze your XRP, that was real. Just like the fact that Coinbase delisted XRP and Kraken, that was real, and everything else is real. So you can believe what you want. You can put the 10 hats on, but it's nonsense. Okay. And when you take that attitude of, hey, it's already been predetermined, all you're doing is letting the bad guys win. Okay. As I tell my 4-year-old daughter when she says, what are you doing, Daddy? I go, I'm fighting the bad guys. Okay. You let the bad guys win. You let the Hinmans win. You let the Claytons win. You let the Gary Genslers win. right? Because they're just going to do their thing, and nothing we do is ever going to change, and throw my hands up and give up. That's what they want. Don't fall for that. Don't let your frustration, your anger and all that cloud you in that way. We keep fighting until there's no fight left to fight. Ripple's fighting. Brad Garlinghouse chose to fight. Chris Larson chose to fight. XRP holders chose to fight. Dragon Chain chose to fight. 16 Amikis chose to fight. Jeremy Kaufman chose to fight. Library chose to fight. Naomi Brockwell chose to fight. All right, now Coinbase is in the fight. Grayscale chose to fight. We just fight until there's no fight to fight, until we win. That's what we do, okay? Let's see. A couple final thoughts. The timing that we're looking at. I've been telling people, like I did today, that is it possible that it goes past September? Of course it's possible. Anything's possible. But the bottom line is, you could look at history. Just like there is that one case I said back when, that it was 6 months after the Daubert decision. Well, that would put us to September 6th. All right. So until she passes September 6th, she didn't do anything that she hasn't done before. And so that's why I said worst case scenario, you're looking at late September, because on September 31st, she would have to report this case. This summary judgment motions have been pending for longer than 6 months. Her name would go on a list. It would go to Congress, and she's never been on that list. I assume she wants to stay off that list, and therefore we will see a decision from today until September 30th. And so for the ones that are out there frustrated, we are this close to getting a decision. We don't know exactly what that decision is going to be, but we're that close. Now, another thing I want to dispel for people out there are so many comments that say, if this judge wasn't on the take, she would have dismissed this case because of all of the corruption and the conflicts of interest and appearances of impropriety. Let me make it clear to you guys right now. There is no motion pending before this judge asking her to dismiss this case for any type of argument like that. Understand, she's a judge. She rules on things that are filed. No one anticipated some crazy guy from Twitter was going to file a motion to intervene after filing a writ of mandamus, arguing that 12,600 and more XRP holders want to be defendants. No one saw that. She reacted. She responded to it. She made us amicus. That's what she does, right? Brad Garlinghouse and Chris Larson filed a motion to dismiss. She ruled on it. The SEC filed a motion to dismiss the fair notice defense. She ruled on it. And no one, Ripple, Brad Garlinghouse, Chris Larson, no one has filed a motion that says, Judge, this case is based on corruption, throw it out. Hasn't happened. So for those out there that keep saying that, then you just misunderstand the way it is. No judge. If I were the judge assigned to this case, and no one has been more critical about the inside shit than me. No one has been after Hinman more than me. And I'm telling you, if I was the judge assigned to this case, I wouldn't just say, oh, you know what, I'm going to throw this case out because someone may have violated the financial conflict laws of the United States. I'm going to throw this case out because Ethereum got a free pass. It's not the way it works. If the judge thought that Bill Hinman violated the law, maybe that's why she said these emails go to impeachment of his credibility. Right? If she thought something was bad, maybe she reports it, but she doesn't say, oh, Ripple gets a free pass because ETH got a free pass. Doesn't work that way. She doesn't say, I'm going to throw the case out because somebody let a group of investors talk them into giving ETH a pass. It does not work like that. I told you guys from the beginning, selective enforcement is not an argument that allows another case. The issue before is, did Ripple sell XRP that violated Section 5 of the Securities Act? All right. This is what she's ruling on, just so everybody understands. She has summary judgment by Brad Garlinghouse and Chris Larson. that I believe she's going to grant, because I don't believe that there is a reasonable jury that would conclude that Brad Garlinghouse and Chris Larson were so reckless to not know that XRP was a security in 2013 and 15 and 17 when the SEC wrote a memo and couldn't conclude it was in 2018. All right. So I think that decision is an easy one. Then she has two other summary judgments to rule on: the SEC summary judgment and Ripple summary judgment. And that's it. Nothing more, nothing less. And if no matter what she thinks about the alleged corruption or conflicts, whatever you want to describe it, doesn't matter. She's going to focus on those particular filings. The SEC summary judgment is going to be based on what she's seen. Did Ripple offer XRP as an investment contract? She's going to look at, did the money that they offered Coinbase, is that enough? Did the money they offered Kraken, is that enough? Did they're putting on their website where you can buy XRP, is that enough? Were the brochure that they sent to 100 investors in 2014, is that enough? That's all she's going to do. She's going to look at that, and then she's going to make a decision. I know she's going to reject the SEC's all-inclusive XRP, no matter who sells it, under no matter what circumstances. She's going to rule against that, but that's her decision. Then she's going to look at Ripple's decision, and she's going to say, okay, do I agree with them that you have to have an underlying contract before you apply the Howey test, right? Do I agree with that argument? And I think she's going to reject that argument. Lewis today was much more, I think diplomatic about it, but I went on record. I think she's going to say a contract, transaction, or scheme. Plain language. The Joyner case, as Lewis brought up today, was a decision a couple years before Howey that found an investment contract, and there wasn't necessarily a written underlying contract in that case. And so those are her decisions that we're going to get, and nothing else. And so that's it. I hope that I've at least convinced some of you that the timeline and all of this, as frustrating as it is not something that points to nefarious things or bad things. Hang in there. We're close to it. I'll see you next week.